Today, we are blessed with the opportunity to discuss the Haven Act, analyzing if, how, and when it will help a financially struggling VA disability recipient in need of bankruptcy protection. We will see it has little to no effect on the totality of circumstances test, though. Hello, I'm Arkansas attorney Greg Niblock, founder of Niblock & Associates, and we practiced bankruptcy law for over 31 years and filed over 15,000 cases. We know the road to the courthouse and how to make bankruptcy work. Now, let's talk about that totality of circumstances test and how the court looks at things. When a motion to dismiss is filed by the United States trustee alleging it would be an abuse of the bankruptcy process to allow a Chapter 7 discharge, considering the totality of the circumstances of the debtor, the court goes through a series of factors to make their decision. The following is a list of the common factors in order of what I think is most important. Number one, whether the expenses can be reduced significantly without depriving the debtor of adequate food, clothing, shelter, and other necessities. Number two, the extent of debtor's ability to repay his debts out of his future earnings. Three, whether debtor enjoys a stable source of future income. And four, whether the debtor's financial situation is the result of an unfortunate catastrophic event. The basic formula for the totality of circumstances test is income minus expenses equals projected disposable income, if any. Now, it sounds simple. However, the devil's in the detail, and applying the factors to the formula can be tricky. So here are the steps. Step one, we must determine projected monthly income. And that's easy because it's all income generated by the debtor's household going forward, regardless of the source, even VA disability or Social Security. Therefore, the Haven Act does not help here. Step two, determining reasonable and necessary living expenses such as food, medical, clothing, shelter, utilities, transportation, or other necessities. What is reasonable and necessary is hard to define. To flesh this out, check out the following. Here's one of my favorite bankruptcy principle sayings. Pigs get fed, hogs get slaughtered. You may say, now Greg, what in the world are you talking about? Think about it. To be a pig implies little, like little pig, let me in. No. And to be a hog implies being too big. Therefore, if the debtor tries to get away with too much, they're seen as a hog and the system is going to slaughter them. However, if they're just a little pig that need to be fed, they're not even going to be noticed. Our next post will continue with step two and show how courts define reasonable and necessary living expenses, whether a debtor has sufficient projected disposable income to be excluded from Chapter 7, and continue to see if, how, and when the Haven Act will help. For a free copy of our special report on the Haven Act, follow this link at www.nibblocklaw.com/Haven or call us at 501-261-6814. Also, we offer a no-obligation debt consultation, a $200 value, free to you if you just give us a call. And remember, at Niblock & Associates, our mission is to restore hope and peace to people in financial distress by hitting the reset button on their bills. If we can be of service to you, your friends or family members for help with bankruptcy, personal injury, wrongful death, Social Security, or tax resolution, please give us a call or visit our website. And until our next post, don't forget, soldier on, be strong, victory is at hand. I love you. Have a blessed day.